Alrighty, so I'm back again to talk about some questions that we get commonly. The second most common question I think that we get, it seems like every week, is something to do with a wrongful termination. A lot of folks call and think that the employer didn't follow the rules, the handbook, did something wrongfully. They say I did something that I didn't do and terminated me. So the best place to start with all of these questions is South Carolina is an employment at will state, and what does that mean? That means that you can be fired at any time for any reason, a good reason, bad reason, no reason at all. The employment status can end unless you have an employee contract. So that's generally where we have to start when we look at some of these situations or cases. And so it's really tough to kind of overcome that burden most of the time. Of course, you can't be terminated for an illegal reason. And that's really a very, very specific exception here in South Carolina, generally having to do with being terminated because you're part of a protected class or you've complained of some sort of unlawful activity. And those are really kind of the limited situations. Now, certainly that unlawful activity could be an unsafe work condition or being asked to do something illegal or seeing discrimination or retaliation occurring and complaining about that. And so those are some of those carved out exceptions. But what I get a lot of is, well, Clay, this is my first discipline and the handbook says, I'm supposed to get a warning or I'm supposed to get this or that. And so they didn't follow the handbook and they fired me. The employee handbook is really not a contract either. The South Carolina courts have said that. Now it can be construed as a contract or contain certain promises by your employer. But about 20 years ago, the South Carolina Supreme Court said, listen, as long as an employee handbook contains a disclaimer in underlined, bold, generally capital letters on the front of the handbook that says this is not an employee contract, it's not changing the terms of conditions of the employment, they don't have to follow it. It's really kind of, a handbook that is some guidelines and some principles, but they absolutely are not obligated to follow it in terms of disciplining folks in South Carolina. So they are very, very fact-specific cases when folks call or think they've been terminated wrongfully or treated wrongfully by their employer. You definitely want to talk with a lawyer who handles employment cases pretty regularly. Now, obviously, though, there are some exceptions to some of those things, and we're looking for some of those exceptions or fact-specific things that you tell us. Now, if you were disciplined, your first warning for something similar that, let's say, a male did and he was not terminated and you're a female, that might raise some questions about gender discrimination, sex discrimination. So those are some of the things we might ask about, but typically we tell folks that the employment at will status in South Carolina is a pretty tough burden to overcome. And I try to tell people, this handbook is really, really not a contract as long as it contains that language on the front. So it's really something you need to be careful about. And it's really something that benefits employers in the state. It's tough to sue employers because of that employment at will status. But if you think you have something, give us a call. We're always happy to listen, answer any questions you have, and try to see if we can help you.